Marriage officer's certificate. Church ministers are appointed as marriage officers. Section 38 of the Marriages Act therefore provides that the minister responsible for the interior may, by executive instrument, appoint a minister of religion to be a marriage officer for the marriage district or district named in the instrument, and may in like manner vary or suspend or revoke the appointment, were any persons desire to marry under the authority of a marriage officer's certificate, those persons shall, for days at least before the time required for the first publication of the marriage, deliver to a marriage officer for the district in which that person resides a notice in the form set out in the 5th Schedule to the Act, Section 48. In other words, this requirement must be complied with where a couple decides to contract marriage in a church, and the notice must be given 4 days prior to the date of the first publication of banns. The notice shall contain the following information: the full names of the bridegroom and bride, status of the bridegroom whether bachelor or widower or married to the woman named in the notice by customary law, status of bride whether spinster or widow or married to the man named in the notice, occupation, rank or profession of each party, age and dwelling place of each party, also indicate consent, if any, and by whom given. Publication of banns entails the announcement of the intention of the parties named in the notice to marry. The person making the announcement shall also call for persons who may know of a just cause why the parties should not be joined together in holy matrimony to come forward and declare it. If both parties have resided in the district for at least 15 days and belong to the same religious denomination, a single notice may be given and one certificate will be issued, per Section 49, on receipt of the notice. The marriage officer shall personally publish the banns of marriage between the parties in the place of worship of the parties, or the marriage officer may authorize another person in writing to publish the banns. Where the parties do not attend the same church, separate notices may be required and banns shall be published in respect of each of the notices, and a joint certificate may be issued. Per Section 50, banns shall be published in the face of the congregation in an audible manner both in English and vernacular at the appropriate time during public divine service on 3 Sundays. And the person publishing the banns shall endorse the dates of such publications on the notice, if no caveat has been entered or if a caveat entered has been duly removed, per Section 53. The marriage officer shall grant the marriage officer's certificate within 3 months from the date of the last publication of banns. Section 54 provides that where the marriage is not solemnized within 3 months of the last publication of banns, the publication and all proceedings consequent on the publication are void. And before the parties can be married by banns, the banns shall be published all over again as if banns had never been published between them. Special license. A special license is applied for when a couple seeks to do away with the giving of notice of the intended marriage between them or the publication of banns. Per Section 55 of CAP 127, where the principal registrar is satisfied by an affidavit that a lawful impediment to the proposed marriage does not exist and that the necessary consent to the marriage has been obtained, the registrar may dispense with the giving of the notice, and with the issue of the certificate of the registrar, and may grant the special license authorizing the celebration of the marriage between the parties named in the license by a registrar, or by a recognized minister of a religious denomination or body. The registrar may also authorize the celebration of the marriage in a place other than a licensed place of worship or a registrar's office. Caveat. A caveat is a legal term used to describe the objection that a person whose consent is required or who may know of a just cause why a marriage should not take place may raise against the issuance of a registrar's certificate or marriage officer's certificate. Per Section 56, where the marriage is to be solemnized under the authority of a registrar's certificate, a person may enter a caveat, before the issue of the certificate, by writing the word forbidden opposite to the entry of the notice in the marriage notice book, and by appending to the notice the name and place of abode of that person, and the grounds on or by reason of which that person claims to forbid the marriage, where the marriage is to be solemnized under the authority of a marriage officer's certificate. A caveat may be entered after the publication of banns by giving notice in writing to the person publishing the banns to forbid the marriage and by appending the name and place of abode of that person to the notice and by specifying in the notice the grounds on or by reason of which that person claims to forbid the marriage, and the person publishing the banns, if not the marriage officer, shall forward the notice to the marriage officer. and shall, unless the notice of the intending marriage has been returned to the marriage officer, record on the notice of intended marriage the fact and date of the receipt of the notice forbidding the marriage. A certificate shall not be issued until the caveat has been duly removed and dealt with. Effect of a caveat, Section 57, where a caveat is entered, the registrar or the marriage officer, as the case may be, shall immediately refer the matter to a justice of the High Court. Where the judge is satisfied that the caveat has no merit, he shall remove it without requiring any of the parties to appear before him. In any other case, the judge shall summon the parties to the intended marriage for the person objecting to show cause why the registrar or the marriage officer should not issue the certificate. The case shall be heard and determined in a summary manner. The judge may also award compensation and costs to the party injured. If the objection is successful, a certificate will not be issued. Removal of caveat, Section 58, where the justice of the High Court decides that the certificate ought to issue, she shall remove the caveat. A. In the case of a registrar's certificate, by cancelling the word forbidden in the marriage notice book in ink, and writing in the marriage notice book immediately below the entry and cancellations, a statement in prescribed form to the effect that the caveat has been cancelled, and signing the book accordingly. B. In the case of a registrar's certificate, by a declaration personally signed by the marriage officer that the intended marriage is proper and may be solemnized in due course, a certified copy of which declaration shall be forwarded by the registrar of the High Court to the marriage officer by whom the caveat was referred. On removal of the caveat, the registrar or the marriage officer may issue the certificate in due course and the marriage may proceed as if the caveat had not been entered. The time that has elapsed between the entering and removal of the caveat shall not be computed in the period of 3 months within which a marriage should be celebrated after the issuance of a registrar's certificate or a marriage officer's certificate. Note that marriages may be celebrated in a licensed place of worship by a recognized minister of the church, denomination, or body to which the place of worship belongs, and according to the rites or usages of marriage observed in the church, denomination, or body. Section 62, 1. Marriages celebrated in licensed places of worship by any recognized minister of the church or denomination shall be celebrated with open doors between the hours of 8 a.m. and 6 p.m. in the presence of 2 or more witnesses besides the officiating minister. Section 62, 2. Per Section 63, no minister shall celebrate any marriage if he knows of any just impediment to such marriage, nor shall he celebrate any marriage until the parties deliver to him either a registrar's certificate or 2 marriage officers' certificate, 1 in respect of each party, or 1 marriage officer's certificate or the registrar's license. Further, no minister shall celebrate any marriage except in a building which has been duly licensed under Section 40 or in a place directed by the registrar's license. Section 64. Note that per Section 74, 2, a marriage is void if both parties knowingly and willfully acquiesce in its celebration, in a place other than the office of a registrar of marriages, a licensed place of worship, except authorized by the principal registrar's license, under a false name or names, without the registrar's certificate of notice. The marriage officer's certificate, or a license from the principal registrar, by a person who is not a recognized minister of a recognized denomination or body or a registrar of marriages. In addition to the above, a marriage will be void in the following circumstances: if bans were not published in accordance with the provisions of the Marriages Act, if a caveat was entered but not removed, if the marriage was not celebrated within 3 months of the date when notice was given to the registrar of marriages, if the marriage was celebrated under an expired license issued by the principal registrar of marriages. What happens after the celebration of a marriage? Immediately after the celebration of a church marriage, the officiating minister shall enter the names of the parties, the status of the parties, occupation and profession of the parties on the certificate. The certificate shall then be signed by the minister, the parties, and by 2 or more witnesses. The minister shall give 1 certificate to the parties and within 7 days shall send the other to the registrar of marriages of the district in which the marriage took place. Where the marriage is celebrated under a registrar's certificate, the registrar shall, after the celebration of the marriage at the office of the registrar, complete the certificate in duplicate. The certificate shall then be signed by the registrar. The parties and witnesses. The registrar shall file one certificate in his office and give the other to the parties. Where the marriage is under a special license, the registrar of the district in which the marriage is to take place shall deliver to the party producing the license a blank certificate of marriage in duplicate, and the minister or registrar celebrating the marriage shall fill up the certificate accordingly and give a copy to the parties. The other copy is sent to the registrar of the district for filing. Per Section 75 of the Marriages Act, marriages celebrated under Part 3 of the Marriages Act is good and valid in law to all intents and purposes. This means that once a valid marriage certificate is produced in court, there should be a presumption that a valid marriage existed between the parties named on the certificate. The burden shall be on the party challenging the existence of the valid marriage to establish same. Conversion. Conversion simply means changing a polygamous marriage to a monogamous marriage or vice versa, whether by contract, statute, or any other legally acceptable means. Marriages are divided into two broad and exclusive categories: monogamous and polygamous marriages. Polygamous marriages are distinguished into potentially polygamous and factually/actually polygamous marriages. A marriage is potentially polygamous where the husband is married to only one woman but has, by law, capacity to become associated with another, or other women in a union to which the relevant laws grant some recognition. A potentially polygamous marriage becomes actually polygamous once the husband has exercised his right and married a second woman by polygamous rights during the currency of the first marriage. A monogamous marriage, on the other hand, has been defined in Hyde v. Hyde as the voluntary union for life of one man and one woman to the exclusion of all others. A monogamous marriage remains monogamous even though there is a real possibility that it could be converted into a potentially polygamous marriage, as noted in the Sinha peerage claim. Equally, a potentially polygamous marriage remains potentially polygamous even though there is a real likelihood that it could be converted into a monogamous marriage. In Soa v. Soa, the parties contracted a potentially polygamous marriage in Accra, the husband being represented by a proxy. He gave a Bible and a ring as a token of his promise to convert the marriage later into a monogamous one. This conversion had not yet taken place when he deserted the woman and their only child in England. It was held that the marriage remained potentially polygamous. There is a general rule which applies the maxim locus regit actum, that an act is governed by the law of the place where it is done, to the formalities of a marriage. Whether any particular ceremony constitutes a formally valid marriage depends solely on the law of the country where the ceremony takes place. This has been stressed in cases such as Herbert, Lady v. Herbert, Lord. It is important to note the application of the law of the place of celebration to the formalities of a marriage is not disturbed even though the sole object of the parties in celebrating their marriage abroad is to evade some irksome requirement of the law of their domicile. Thus, in Simonin v. Malac, two persons French by domicile contracted a marriage in London which, though formally valid according to English law, would have been void if tested by French law since parental consent had not been obtained. The wife petitioned for a decree of nullity. The court dismissed the petition, for, since the necessary consent, as we have seen, was nothing more than a formality, its absence could not affect a marriage celebrated in England. A customary law marriage may be changed to a monogamous marriage and a Mohammedan marriage may be changed to a monogamous marriage. The conversion may be through legislation or change of domicile or religion, as noted in Parkasho v. Singh. In Ghana, only change by legislation and change by domicile are applicable. Conversion through legislation. In order to successfully convert a valid customary law marriage from polygamous to monogamous through legislation, the parties must strictly comply with the mandatory provisions of Part 3 of the Marriages Act, CAP 127. Failure to comply with the mandatory provisions of the Act relating to procedure will vitiate the attempt at conversion, and the parties will, to all intents and purposes, continue to be in a polygamous marriage. According Section 74, 2, provides that a marriage is void if both parties knowingly and willfully acquiesce in its celebration in a place other than the office of a registrar of marriages, or a licensed place of worship, except where authorized by the registrar's license, or under a false name or names, or without the registrar's certificate of notice, or the marriage officer's certificate, or one certificate when sufficient or license duly issued, or by a person who is not a recognized minister of a religious denomination or body or a registrar of marriages, in re Appia, Dec, Yeboah v Appia, 1 John Owusu Appia and his wife were married under customary law. They decided to convert the marriage to a monogamous marriage under CAP 127. They went through a blessing ceremony at the local Methodist church. The ceremony was officiated by the minister in charge and a certificate was issued. There was no evidence to show that the mandatory provisions of CAP 127 were complied with. The deceased remained married to the wife until he died. The court held that the wife could not benefit under CAP 127 because its provisions were not adhered to. The marriage was still a customary marriage and the law applicable to the distribution of the estate of the deceased was the customary law. By custom, the deceased's properties vested in the customary successor. The mere intention of the parties to convert is not enough. Also in Setz v. Setz and Carr v. Carr, the court held that the provisions of the marriage ordinance, CAP 127, had not been complied with and therefore the conversion had not taken place. Apamasu v. Brahmayuo another, re Birathia here, ex part Ali, Jabil another v. Ishkur another. It is important to note that blessing is not the same as marriage. Blessing occurs when parties to a polygamous marriage go through a marriage ceremony in the church and receive blessings from a priest. No certificates are required, bans need not be published. The place for the blessing need not be licensed and the officiating person need not be a recognized minister of a recognized denomination or body. The character of the marriage does not change. The marriage continues to be polygamous. The parties to such a marriage still remain subject to all the consequences, incidents, and effects of a customary marriage. As noted in Graham v. Graham, the union continues to be loose and the man is not precluded from taking on as many wives as he can harmoniously live with and conveniently manage. In Graham v. Graham, the parties were married under customary law. They later went through a marriage ceremony at the Roman Catholic Church at Zelyakope. The husband subsequently instituted an action at the Tima City Council for the dissolution of the customary marriage. The court held that the ceremony at the church complied with all the requirements of CAP 127 and therefore the customary marriage was effectively converted to a monogamous marriage. The conversion conferred on the parties obligations, rights, and privileges totally different from those under customary law. The parties after the conversion renounced their rights, obligations, and privileges under customary law. The customary law marriage disappeared and its place was taken by the ordinance marriage which the local council had no jurisdiction to dissolve. Conversion through change of domicile. If one of the parties to a potentially polygamous marriage acquires a domicile of choice in another country, the marriage automatically converts to a monogamous marriage if marriage in the new domicile is monogamous. In Ali v. Ali, the parties contracted a potentially polygamous marriage in India. The parties moved to England but the wife returned to India after a short stay. The husband acquired a domicile of choice in England and applied for a divorce in an English court. The court held, inter alia, that the acquisition of the English domicile changed his marriage from a potentially polygamous marriage to a monogamous marriage and therefore the court had jurisdiction over the matrimonial offences committed after the change. Note that under Ghanaian law, change or religion will not change the character of a marriage. If a couple married under customary law changes their religion, that change per se would not change the character of the customary marriage from polygamous to monogamous. Effect of a conversion. A successful conversion dissolves the customary marriage. The customary marriage completely disappears and its place is taken by the ordinance marriage. In essence, the customary marriage ceases to exist as is clear in Graham v. Graham. Likewise, after the dissolution of a monogamous marriage, there is no other marriage to be dissolved because the customary marriage would have fallen away as soon as the monogamous marriage is contracted. Again, if conversion is not successful, the marriage continues to be customary and therefore potentially polygamous. The man may therefore marry other women but only under customary law. If he marries any woman under the Marriages Act, that marriage is null and void and of no effect. The issue of the status of an earlier marriage after conversion was discussed in Ohoku v. Ohoku. In that case, the parties were Nigerian Christians who married in 1949 in Nigeria according to custom. They went to England and went through a second marriage in 1953 in a marriage register office in London. After 3 years, the wife filed a petition for divorce in an English court. It was submitted that as soon as the parties went through the second marriage in 1953, the first marriage was automatically dissolved and there was no longer another marriage that should have engaged the attention of the judge. The judge held that whatever might be the effect of the parties being Christians on the marriage for other purposes and in other courts. In this court and for this purpose, the Nigerian marriage must be regarded as a polygamous marriage over which this court does not exercise jurisdiction. He therefore pronounced a decree of dissolution, not of the Nigerian marriage, but of the marriage in London. The Ghanaian case of Graham v. Graham settled the legal position in Ghana discussed above. Also in Ramia v. Ramia, Qureshi v. Qureshi, Baraki v. Baraki, Attorney General of Ceylon v. Rid, nullity proceedings. The proceedings for bringing a void or voidable marriage to an end are known as nullity proceedings. These proceedings are governed by Section 13 of the Matrimonial Causes Act, which states inter alia that any person may present a petition to the court for a decree annulling his marriage on grounds that the marriage was by law void or voidable. Void marriages. A void marriage is a marriage which is so defective that the law regards it as being non-existent. It is a marriage that does not comply with the substantive or procedural requirements in Section 74 of CAP 127. It is one which has some incurable defect and can never be valid, regardless of the intention of the parties. In de Reneville v. de Renaville, the court held that a void marriage is one that will be regarded by every court in any case in which the existence of the marriage is an issue as never having taken place and can be treated by both parties to it without the necessity of any decree annulling it. A decree is not needed to set aside a void marriage because such a marriage never comes into existence and as such there is nothing to set aside. Either party to a void marriage may lawfully contract a valid marriage with someone else without having the first marriage annulled. Re Roberts. Section 13(4) of the MCA therefore provides that nothing in the section shall be construed as validating a marriage which is by law void but with respect to which a decree of nullity has not been granted. However, a party to a void marriage may apply for a decree to declare a marriage void for 2 reasons. Firstly, a party may use the opportunity to apply for ancillary reliefs such as custody and maintenance, and secondly, the decree will prove to the whole world that the marriage was never valid. The only remedy to a void marriage requires the parties who wish to maintain the relationship to start again from scratch. With a new effective ceremony, this time complying with the law and practice of any jurisdiction which has a matrimonial regime, unlike voidable marriage, there are no defenses to a void marriage. It cannot be cured or rectified. After the death of one of the spouses, an application can be brought to declare a void marriage null and void and of no consequence. The validity of a void marriage may be challenged by a third party. Thus, a family representative may raise an issue to the effect that a surviving spouse cannot benefit under the Intestate Succession Act 1985. Law 111 became the marriage between the deceased and the surviving spouse null and void. A marriage may be said to be void in the following circumstances: no publication of banns, using a false name, marriage officer not licensed, place of ceremony not licensed, none of the certificates issued, non-registration of Mohammedan marriage, consanguinity and affinity, bigamy, child marriages. Ghanaian cases on void marriages, in Rieri Edi, Dect, Eri Edi v Okwabi, Genfi 2 v Genfi 2, Jabil and another v Ishkur and another, Cecilia Osei Owusu v Akoju Amansa James Osei, Ruth Arthur v John Hector Ansa Naomi Owusu, Eleanor Asigbe v Dr. Solomon Fia another, Mrs. Mary Aguman Ainer v Kwasi Bokai Ainer. Voidable marriages. Voidable marriages are governed by Section 13 of the MCA. A voidable marriage is one which is valid for all purposes until nullified. A process which can only be effected by the parties to the marriage who may affirm it instead if they wish, and no other person may attack its status unlike a void marriage. Accordingly, Green Mr. states concerning avoidable marriage that it is one that will be regarded by every court as a valid subsisting marriage until a decree annulling it has been pronounced by a court of competent jurisdiction. These are marriages that remain valid until annulled by a decree issued by a court of competent jurisdiction. The characteristics of avoidable marriage are as follows: it is valid until declared void by the court. The parties to the marriage are the only ones who can end it. A third party cannot petition to have it annulled. A decree is needed to nullify a voidable marriage. The marriage remains valid until a decree setting it aside is issued. If an application is not brought to set it aside, the marriage continues to be valid. A petition for a decree of nullity is not allowed after the death of one of the spouses. A party to a voidable marriage cannot enter into a valid marriage with a third party until the voidable marriage has been annulled. What circumstances will render a marriage voidable? Per Section 13 of the MCA, a marriage is voidable on the ground, a. that the marriage has not been consummated owing to the willful refusal of the respondent to consummate it. Or, b. that at the time of the marriage either party to the marriage was of unsound mind or subject to recurrent attacks of insanity, or c. that the respondent was at the time of the marriage pregnant by some person other than the petitioner, or d. that the respondent was at the time of the marriage suffering from an incurable venereal disease in a communicable form. In all these circumstances, the court will not grant the decree of nullity in cases falling within paragraphs b, c, or d unless it is satisfied that a. the petitioner was at the time of the marriage ignorant of the facts making the marriage voidable and b. proceedings were instituted within a year from the date of the marriage and c. marital intercourse with the consent of the petitioner had not taken place since the petitioner discovered the existence of the facts making the marriage voidable. A petitioner may consider filing a petition for divorce where the voidable marriage is more than 1 year. The distinction between void and voidable marriages is clearly stated in de Reneville v. de Reneville by Lord Green Mr. in the following words: a void marriage is one that will be regarded by every court in any case in which the existence of the marriage is an issue, as never having taken place and can be so treated by both parties to it without the necessity of any decree annulling it. A voidable marriage is one that will be regarded by every court as a valid subsisting marriage until a decree annulling it has been pronounced by a court of competent jurisdiction. Consummation. Consummation refers to the achievement of full and complete penetration as noted in WVW. A transient penetration will not amount to consummation of a marriage. Consummation should be looked at from the angle of inability to have sexual intercourse and willful refusal to have sexual intercourse. Incapacity. The condition causing inability to consummate must be serious and incurable for the court to hold that a marriage is voidable. Incapacity must be in existence at the date of the marriage and there must be no practical possibility of consummation the date of the hearing. In Napier v. Napier, it was necessary to seek an adjournment because the wife had an operation 6 days before the hearing. And the petition was eventually dismissed as the incapacity was curable. Inability to ejaculate or sterility on the part of one of the parties would not amount to non-consummation. In SVS, the couple could not have sexual intercourse because the wife had a malformed vagina. A petition based on non-consummation was refused by the courts on the grounds that the wife's condition could be cured by operation. The marriage was, however, dissolved as a result of the husband's adultery. As noted in WVW, ejaculation per se does not amount to consummation. In this case, the husband occasionally penetrated the wife for a short time, but soon after his erection collapsed and he came out of her. It was held that the marriage had not been consummated and that the cause of the non-consummation was the impotence of the husband. In the words of Brandon J., the question whether there has been consummation of the marriage or not is primarily a question of fact, and the question which has to be determined is whether there has been sexual intercourse, which in the proper meaning of the term is ordinary and complete intercourse. It does not mean partial and imperfect intercourse. The court was therefore of the opinion that penetration maintained for so short a time, resulting in no emission either inside the wife or outside her, cannot without violation of language be described as ordinary and complete intercourse. Therefore, the marriage had not been consummated and the non-consummation was caused by the impotence of the husband existing at the date of the marriage. the use of condoms does not amount to non-consummation according to Baxter v. Baxter. In this case, H was not allowed by W to have sexual intercourse with her unless he used a contraceptive sheath because she feared childbirth. He reluctantly complied because he thought W would not have it any other way for 1934 to 1944. He filed nullity proceedings against W for refusing to consummate the marriage. The House of Lords held that marriage had been consummated and the use of a contraceptive sheath was irrelevant to the question of consummation. Also, the practice of coitus interruptus does not amount to non-consummation. In Cackett v. Cackett, the husband persistently practiced coitus interruptus against the wife's wishes as he did not want children. The wife filed for a decree of nullity on the ground of willful refusal to consummate marriage and in the alternative a decree of divorce on the ground of cruelty. The court held that the marriage had been consummated but rather granted the divorce if the condition causing the incapacity can be removed without resulting in danger to a spouse. The court will hold that the marriage is not voidable as noted in Napier v. Napier. The impediment must exist at the time of the presentation of the petition. If the impediment has been removed or the party is prepared to undergo an operation or receive treatment to remove the impediment, the petition will fail. In SVS, the wife's incapacity was due to thick hymen which made penetration impossible. The husband subsequently sought a decree of nullity alleging that the wife was at the time of the marriage, and have ever since, been incapable of consummating the marriage. Before the hearing of the petition, the operation of hymenectomy was successfully performed on the wife. The court held that the husband had failed to prove that the marriage had not been consummated owing to the wife's incapacity because an operation had remedied the impediment at the time of the hearing. A petition based on psychological inability to consummate a marriage may be successful if the petitioner is able to establish that he or she finds sexual intercourse extremely repugnant. In Clark v. Clark, the wife was frigid and was said to have had an involuntary muscular spasm which contracted the vagina on the approach of the male organ. The courts held that the marriage had not been consummated even though the woman had given birth through fecundation ab extra. Willful refusal. Willful refusal occurs when one of the parties refuses to have sexual intercourse without just cause. Samuel Evans P. and Dickinson v. Dickinson defines willful refusal as not a mere temporary unwillingness due to a passing phase or the result of coyness. A feeling of delicacy, affected or real, or a nervous ignorance which may be got rid of by forbearance, care and kindness, but willful, determined and steadfast refusal to perform the obligations and to carry out the duties which the matrimonial contract involves. Willful refusal includes refusal to undergo an operation to cure the condition which is hindering consummation or consistent and steadfast refusal without just cause. In Jodla v. Jodla, the parties agreed to marry first at the registry and then later at the church. They agreed further that they would only live together as husband and wife after the church wedding. The husband subsequently refused to go through with the church wedding. He was deemed by the court to be in willful refusal to consummate the marriage. Kaur v. Singh was a similar case, where the parties were Sikhs. It was intended according to the religious and social custom of their people that a religious ceremony would have to follow, but the husband who had the obligation of arranging that ceremony refused to do so, and this was held to amount to refusal to consummate. In Ford v. Ford, the husband was in prison for 5 years and the marriage actually took place in prison where there was no opportunity for consummation. When he was eventually released on a visit prior to the end of his sentence, he did not go home but stayed with a former girlfriend. When the wife eventually petitioned, it was held that he had not refused consummation in prison as there were no facilities, but he had done so as soon as he had the opportunity on a visit out of prison prior to his release, so that his conduct then had demonstrated willful refusal to consummate the marriage either at that time or in the future. Once sexual intercourse takes place, the marriage becomes consummated and ceases to be voidable. An aggrieved party may petition for divorce if there are facts to prove that the marriage has broken down beyond reconciliation. Only one incidence of sexual intercourse is needed to consummate a marriage. The distinction between the act of intercourse and the possibility of that act resulting in the birth of a child must be kept clear. Once the parties have had intercourse, the marriage is consummated even though one or both are infertile. If this were not so, the marriage could never be consummated if, for example, the wife were beyond the age of childbearing. Conversely, if the spouses have not had intercourse, the birth of a child as the result of artificial insemination or any form of assisted reproduction technique would not amount to consummation. Unsound mind. This will affect a marriage only if, as a consequence, at the time of the ceremony either party was unable to understand the nature of the contract he was entering into. There is a presumption that he was capable of doing so, and the burden of proof lies on the party impeaching the validity of the marriage. The test was formulated in and re-estate of Park as capability of a person to understand the nature of the responsibilities that attach to marriage. Without this degree of mentality, it cannot be said that the person understands the nature of the contract of marriage. In Bennett v. Bennett, the wife was not clinically ill, but suffered from a temporary hysterical neurosis which meant that she was likely to be difficult on a short-term basis, but this was insufficient to invalidate the marriage. Duress. It must be shown that there was absence of real consent by either party. Validity of consent is vitiated if it can be shown that a spouse, at the time of the ceremony, was under threat which effectively destroyed the reality of that consent. In Schechter v. Schechter, it was stated that the will of one of the parties must be so overborne by genuine and reasonably held fear that the constraint destroys the reality of consent. In this case, a Polish woman in prison in Poland following arrest by the security forces, married so that she could leave both prison and Poland itself. It was accepted that she was in poor health and that her life was in danger if she remained, and this was accepted as sufficient duress for a decree to be granted. Hussein v. Hussein was another case of marriage entered into under threat of being killed by the husband. Effects of an annulment. Avoidable marriage becomes void after it has been annulled by a court of competent jurisdiction. Status of children of an annulled marriage. Section 14 of the MCA states that where a decree of nullity is granted, a child of the parties to the decree shall be deemed to have the same status and rights as if the marriage of the parents had been dissolved rather than annulled. The fact that the marriage has becomes void shall not affect the legitimacy of the children. Presumption of death and dissolution of marriage. Section 15(3) of the MCA provides that the fact that for a period of 7 years or more the other party to the marriage has been continually absent from the petitioner and the petitioner has no reason to believe that the other party has been living within that time, shall be evidence that the other party is dead until the contrary is proved. This is a rebuttable presumption. Section 33(1) of the Evidence Act 1975 NRCD 323 also contains a rebuttable presumption which states that where a person has not been heard of for 7 years despite diligent efforts, whether or not within that period, to find him, he is presumed to be dead. The Evidence Act. Section 31 of the Evidence Act provides that a marriage which has been celebrated before witnesses is presumed to be valid. This section is applicable to both monogamous and polygamous marriage and applies whether or not the witnesses to the marriage are called as witnesses in the action. It has been argued by some writers that for a marriage to be valid, there must be a celebration and that because informal marriages are devoid of celebration, they cannot be valid. This submission cannot entirely be correct for a number of reasons. The correct interpretation of Section 31(1) is that if there is evidence that a marriage was celebrated before witnesses, that act alone is enough to establish a rebuttable presumption that the marriage is valid. The burden will therefore lie on the person challenging the validity to rebut it. On the other hand, if a marriage has not been celebrated before witnesses, that presumption will not apply. Consequently, the person who claims that there is a valid marriage will bear the burden of establishing that, indeed, there was a valid marriage. In cases of informal marriage, the burden will be on the person who claims that there was a valid marriage to establish that even though there was no celebration, in substance, he or she lived with the other party as husband and wife. Furthermore, the section does not state either categorically or in necessary implication that a marriage that has not been celebrated before witnesses is not valid. Consequently, the decisions declaring that informal marriages are valid marriages could not have been decided per incurriam. Section 32 of the Evidence Act also states that a child born during the marriage of the mother is presumed to be the child of the person who is the husband of that mother at the time of the birth. A child of a woman who has been married, born within 300 days after the end of the marriage, is presumed to be a child of that m.